The house had always stood slightly apart from the rest of the neighborhood, not by distance alone, but by intention. It sat on the edge of the development where the land sloped gently downward, just far enough from the identical rows of trimmed lawns and matching mailboxes to feel independent. Long before the neighborhood association existed, before rules and fees and committees, the house had been there, built under older covenants that granted its owner a freedom the newer residents never questioned until it was too late. When the Homeowners Association was formed, it came with glossy pamphlets and cheerful promises: order, safety, property value protection, the kind of words that sounded harmless enough to anyone who believed authority only existed to serve. But the house on the edge never signed the papers. It never joined. And legally, it didn't have to. That single fact became an unspoken irritation from the moment the HOA board realized it couldn't assert control. At first, the resistance was subtle. Notices appeared in the mailbox referencing violations that didn't apply. Lawn measurements taken from the sidewalk, anonymous complaints about imaginary noise. Then came the letters, formal, printed, stamped with authority that didn't exist. Each one assumed eventual compliance, because compliance was what everyone else did. But the homeowner knew better. Years earlier, he had worked in policy and legislative drafting, buried deep in municipal law where property rights and association powers were defined line by line. He had helped shape statutes meant to protect homeowners from overreach, written in careful language designed to survive abuse. Those laws were never supposed to be tested by arrogance. Yet here they were, ignored by people who assumed rules were whatever they said they were. The HOA board didn't know his history. They didn't bother to check. To them, he was just another obstacle, a holdout threatening uniformity. As months passed, the notices escalated. Fines were issued that held no legal weight, late fees stacked on imaginary balances, threats of liens that could never be filed. Every tactic relied on fear and ignorance, the same way the HOA handled everyone else. But fear never came, only silence. That silence infuriated them. The neighborhood itself had changed since the HOA took hold. Surveillance cameras sprouted on doorways like mechanical eyes. Neighbors stopped waving and started watching. Every deviation from the approved aesthetic became a silent offense, logged in private group chats and emailed reports. The association thrived on compliance, and nothing disturbed it more than someone who refused to bow. Board meetings grew tense. Discussions that should have focused on maintenance turned obsessive. The house on the edge was mentioned again and again, framed as a threat to property values, a liability, a dangerous precedent. It wasn't about grass or paint colors anymore. It was about control. The board president pushed hardest. A retired middle manager with too much time and too little authority elsewhere, he treated the HOA as a kingdom. Rules were weapons, enforcement was personal, and defiance was unforgivable. When legal pressure failed, the harassment shifted into something quieter and more disturbing. Contractors were sent to the property without permission. Utility companies received false reports. A tow truck once appeared confused before leaving. Each incident was small enough to be dismissed, but together they formed a pattern. Someone was probing boundaries, testing how far they could go without consequences. The homeowner documented everything: photographs, dates, names, copies of letters, screenshots of messages forwarded by sympathetic neighbors who were starting to feel uneasy. The file grew thicker with each passing week. Still, he stayed put. Leaving would have been easier. Selling would have avoided conflict, but principles once compromised never returned intact. Then the warning stopped. No letters, no notices, no fines. For the first time since the HOA's formation, there was nothing. The quiet felt wrong, not peaceful, but anticipatory, like the pause before something irreversible. The night the fire started, there was no storm, no lightning, no accident waiting to be blamed. The homeowner had been away, returning late, the road ahead lit by flashing lights that made no sense at first. Smoke hung low in the air, thick and bitter, visible from blocks away. By the time he reached the property, the house was already lost. Flames had consumed the structure with unnatural efficiency. The roof collapsed inward like it had been weakened beforehand. The fire department moved with grim professionalism, but there was nothing left to save. Ash drifted across the yard, settling over everything like a final insult. Investigators would later say the fire's origin was suspicious. Accelerants, multiple ignition points, the kind of fire that didn't happen by chance. But that night, none of that mattered. The house that had stood independent for decades was gone, reduced to charred beams and blackened foundations. Memories erased in hours, and as the smoke rose into the night sky, something else became clear. Across the street, curtains shifted. Porch lights flicked on. Phones were raised discreetly. No one approached. No one offered help. Some faces held shock. Others held something closer to satisfaction. By morning, the rumors had already started. Whispers moved through the neighborhood faster than the investigators. The story morphed with every retelling: electrical failure, old wiring, neglect, subtle suggestions that the homeowner had brought it on himself by refusing to follow community standards. The HOA board released a carefully worded statement expressing sympathy while distancing itself completely. They emphasized safety, compliance, the importance of unity. They reminded residents how dangerous it was to ignore association guidelines. Behind closed doors, relief settled in. The problem had solved itself. Without a house, there was no refusal, no defiance, no edge property threatening their authority. The land would eventually be sold, rebuilt, absorbed into the uniform grid they controlled. Order would be restored. What they didn't know, what they never considered, was that destruction didn't erase documentation. Fire didn't burn understanding, and intimidation didn't work on someone who knew exactly how power was supposed to be limited. As investigators sifted through the ashes, the homeowner stood quietly at the edge of the lot, watching the smoke fade. There was grief, but it was layered beneath something colder, something patient. He already knew this wasn't just arson. It was a confession, and as the neighborhood went about its routines believing the conflict had ended, a far more dangerous process had already begun, one that would expose every illegal vote, every forged notice, every abuse of authority the HOA had committed since its creation. The fire had taken a house, but it had also lit something else entirely, and the HOA had no idea what was coming next. In the days that followed the fire, the neighborhood returned to its routines with unsettling speed. Lawns were watered on schedule. Trash bins appeared and disappeared with mechanical precision. The HOA's social media page posted reminders about approved mailbox colors and parking restrictions, as if nothing of consequence had happened. The burned property became an uncomfortable landmark people avoided looking at for too long. A blackened gap in an otherwise perfect pattern. To the HOA board, the silence felt like victory. They assumed grief would do what threats had failed to accomplish. Without a house, they believed resistance would collapse into exhaustion, insurance claims, and eventual departure. They underestimated the kind of person who had refused them in the first place. The homeowner didn't leave town. He didn't lash out publicly. He didn't argue online or confront anyone in the neighborhood. Instead, he moved methodically, the way someone does when they understand that the truth, properly revealed, can be far more devastating than anger. The first step was documentation recovery. While the house was gone, the records were not. Copies existed in secure cloud storage, off-site backups, and physical files kept elsewhere long before the fire. Every notice, every fine, every unauthorized inspection attempt had been preserved. Even the HOA's own communications, obtained through neighbors who had grown uneasy with the board's obsession, were catalogued and indexed. Patterns emerged immediately. Dates of alleged violations coincided with HOA board meetings where enforcement strategies were discussed. Complaints originated from the same handful of board members, often submitted anonymously. Fines were issued under provisions that didn't exist in the bylaws, or worse, contradicted state law outright. None of this surprised him. It confirmed what he had suspected all along. The next step was the investigation itself. Fire officials had already labeled the blaze suspicious. Accelerants don't lie, and neither do burn patterns. Multiple points of origin indicated planning, not accident. While the investigation proceeded quietly, the homeowner requested records through proper channels, leveraging public access laws he knew intimately, reports, timelines, internal notes. Each request was precise, impossible to deny without cause. At the same time, he began reviewing the HOA's legal foundation. The association had been formed hastily years earlier during a rapid expansion of the neighborhood. Developers had rushed paperwork. Homeowners had signed without reading. The HOA's authority rested on documents that assumed universal participation, even though the law didn't support that assumption. His property, built under older covenants, had never been legally annexed into the association's control. That fact alone should have limited the HOA's actions. Instead, they had acted as if authority was something they could simply declare. The deeper he looked, the worse it became. The HOA board had exceeded its powers repeatedly. They had voted on enforcement actions without quorum. They had imposed fines without due process. They had threatened liens without legal standing. They had accessed private property without consent. And in several instances, they had falsified records to make their actions appear legitimate. Each violation was minor on its own. Together they formed a pattern of systemic abuse. Meanwhile, the board grew bolder. Without opposition, they interpreted silence as permission. They discussed future plans openly in newsletters and closed meetings, rezoning proposals, expanded enforcement, increased fees. They framed the burned house as a cautionary tale, a reminder of what happened when people refused to participate in the community. Neighbors noticed the shift. Some felt relieved that conflict was gone. Others felt uneasy, realizing how quickly the association had moved on. A few began quietly reaching out, offering information without attaching their names. Screenshots of emails, copies of internal memos, meeting notes that had never been shared publicly. Fear was spreading even if no one admitted it aloud. The homeowner accepted everything without commentary. He knew timing mattered. Confronting the HOA too early would only give them time to cover tracks, destroy records, adjust stories, pressure witnesses. Instead, he waited while the investigation continued and the board grew more careless. Behind the scenes, he began preparing something far larger than a complaint. Years earlier, when state lawmakers had debated revisions to homeowner association statutes, he had been part of the drafting process. His role had been technical, not political. He specialized in limiting abuse, writing safeguards that assumed bad actors would eventually emerge. Those laws required transparency, due process, and strict limits on enforcement authority. The HOA had violated nearly every one of them. What made this situation different was evidence, not theory, not interpretation. Evidence tied directly to actions, dates, and individuals. Evidence backed by their own words and documents. As the fire investigation reached its midpoint, the homeowner took another step. He filed formal requests for HOA financial records. Associations were required by law to provide them upon request. The board delayed, citing administrative burdens. He followed up with statutory deadlines attached. They provided partial records. He documented the omissions. What he found raised even more concerns. Funds allocated for maintenance had been redirected without explanation. Legal expenses were hidden under vague categories. Payments had been made to contractors with personal connections to board members, the same contractors who had previously shown up at his property uninvited. Coincidence had long since left the conversation. By now, the board had begun to sense something was wrong. Their emails grew defensive. Their meeting agendas shifted toward legal strategy. They consulted attorneys who reassured them, unaware of the full scope of what was coming. The board clung to the belief that they were untouchable because no one had ever challenged them before. They mistook precedent for permission. The homeowner waited for the fire investigation to reach its conclusion. When it did, the findings were devastating. The report confirmed arson, intentional, coordinated. While it didn't name suspects immediately, it established criminal activity connected to the property. Insurance companies took notice. Law enforcement escalated. Subpoenas followed. Suddenly, the burned house was no longer a closed chapter. It was the center of a widening inquiry. The HOA tried to distance itself further, issuing another carefully worded statement emphasizing cooperation with authorities. They encouraged residents not to speculate. They reminded everyone of the importance of unity during difficult times. Behind closed doors, panic began to replace confidence. Records that should have existed were missing. Emails had been deleted too late to matter. Votes that had never been properly recorded were now being questioned. The board members who once spoke with certainty began deflecting responsibility. And still the homeowner said nothing publicly. He let the pressure build. Because what he was preparing wasn't just a response to arson, it was a reckoning with an organization that had operated without accountability for years. A reckoning designed to unfold in stages, each one legally unavoidable. The fire had destroyed a house, but it had also stripped the HOA of the illusion that they controlled the narrative. As the investigation closed in and the paper trail thickened, the board faced a reality they had never considered. The man they tried to intimidate wasn't just knowledgeable. He was prepared, and the next move would ensure they could never quietly recover from what they had done. The neighborhood didn't know it yet, but the story was far from over. It was only moving into a phase where consequences could no longer be delayed. The shift began quietly, the way real consequences often do. There was no announcement, no dramatic confrontation, no sudden collapse of authority. Instead, small changes appeared in places the HOA couldn't control. Certified letters started arriving at board members' homes, not warnings, not demands, formal notices requesting preservation of records. Each one referenced specific statutes, complete with citations and deadlines. They were written with surgical precision, leaving no room for interpretation or delay. Ignoring them would carry penalties. Responding to them would expose more than the board was ready to reveal. The board called an emergency meeting. Attendance was mandatory. Panic disguised itself as urgency as members scrambled to reassure one another. They convinced themselves this was manageable, just another complaint that could be smoothed over with the right language and legal posturing. They had lawyers, they had money, they had never lost before. What they didn't have was control over the process anymore. The homeowner filed his first formal complaint shortly after the preservation notices were delivered. It wasn't filed with the HOA, and it wasn't addressed to local authorities alone. It went to multiple oversight bodies simultaneously, each one empowered to investigate different aspects of HOA conduct: housing regulators, consumer protection agencies, the state office responsible for association governance. Each complaint contained the same core facts, but tailored carefully to the authority of the recipient. This wasn't accidental, it was strategic. The filings outlined a pattern of harassment, unauthorized enforcement, financial mismanagement, and legal overreach. They were supported by exhibits that spoke louder than accusations ever could. Emails, meeting minutes, financial summaries, screenshots of internal communications, photographs of unauthorized inspections. Each piece was labeled, indexed, and cross-referenced. The complaints didn't accuse anyone of arson. They didn't need to. By the time regulators began reviewing the materials, the fire investigation was already active, and the connection was impossible to ignore. The burned house wasn't just a tragedy, it was context, a culmination of unchecked authority meeting resistance. The HOA board learned about the filings the same way they learned about everything else, too late. Regulators contacted them directly, requesting documentation they had already been warned to preserve. Suddenly, deadlines mattered. Suddenly, informal practices became liabilities. Suddenly, the lack of proper records was no longer a convenience, but a red flag. The board's attorney shifted tone. Where there had once been confidence, there was now caution. Requests for extensions were made. Partial disclosures were offered. Explanations were crafted to sound reasonable, but they fell apart under scrutiny. The problem wasn't one violation, it was dozens, layered over years. Meanwhile, the homeowner continued assembling the final piece of his response. He prepared a civil action. Not a lawsuit driven by emotion, but one designed to expose structure. The filing laid out the legal history of his property, the limitations of HOA authority under state law, and the specific statutes the board had violated. It cited case law he knew intimately, precedents he had helped influence indirectly through legislative drafting. The complaint named individuals, not just the association. Board members were listed in their personal capacities where the law allowed. Fiduciary breaches, willful misconduct, abuse of authority. Each claim was grounded in documented action, not assumption. Each one carried consequences that couldn't be brushed aside by insurance alone. The filing also included a request for injunctive relief. If granted, it would immediately suspend the HOA's enforcement powers pending investigation. No fines, no notices, no liens, no authority. The association would be reduced to a maintenance entity, stripped of its ability to intimidate or retaliate. The request was urgent. The justification was undeniable. When the filing became public record, the neighborhood felt it instantly. Rumors exploded into conversations. People who had stayed silent began asking questions. Homeowners pulled out their own letters and fines, comparing them to what they were reading online. Patterns emerged that mirrored the homeowner's experience almost exactly. Fear shifted direction. Now it wasn't about violating HOA rules. It was about what the HOA had been doing behind closed doors. Attendance at board meetings spiked. Residents demanded explanations that never came. The board attempted to reassure everyone through newsletters that grew longer and less coherent with each edition. They insisted everything was under control while simultaneously warning residents not to speak to investigators without counsel. That contradiction didn't go unnoticed. The fire investigation took another step forward. Subpoenas were issued for electronic communications tied to specific dates. Contractors were interviewed. Financial records were traced. The same names kept appearing in different contexts. The same decisions repeated themselves under different justifications. While no arrests were made yet, the direction was clear. This was no longer just about a house. It was about power and how easily it had been abused when no one thought to challenge it. The homeowner watched the developments without celebration. He understood that exposure was only the beginning. Accountability required patience. Systems resisted correction, especially when they had benefited so many for so long. But he also knew the law didn't care about discomfort. It cared about compliance. Behind the scenes, settlement discussions were quietly floated by the HOA's council. They suggested compensation, rebuilding assistance, confidential agreements, anything that would make the problem go away. The homeowner declined every offer. Silence in this case was not weakness, it was resolve. Accepting a settlement would end the story quietly. It would allow the HOA to survive, bruised but intact, free to resume its behavior once the attention faded. That wasn't justice, it was convenience. And convenience was exactly what had allowed this situation to exist in the first place. As regulatory investigations intensified, cracks began to form within the board itself. One member resigned, citing personal reasons. Another stopped attending meetings. A third quietly retained separate legal counsel. Loyalty eroded when consequences became personal. The unity the HOA preached had never extended to accountability. The homeowner knew this phase well. It was the unraveling. The moment when people who once spoke collectively began protecting themselves individually. When stories changed. When memories became selective. When responsibility was quietly redirected toward whoever seemed most expendable. He continued to wait. Because the next chapter wouldn't be driven by regulators or courts alone. It would be driven by something the HOA had never anticipated. The public realization that the man they targeted wasn't just informed. He had helped write the very framework now being used against them. And once that truth surfaced, the narrative would shift in a way no amount of legal maneuvering could undo. The association had burned down a house. What they were about to lose was far more permanent. The moment the truth surfaced, it didn't arrive as a dramatic reveal or a public announcement. It emerged gradually, slipping into the narrative through documents, filings, and quiet confirmations that were impossible to deny. The homeowner's background became visible not because he advertised it, but because the legal record made it unavoidable. Court filings referenced statutes in unusually specific ways. Legislative history was cited with an intimacy that suggested authorship, not just familiarity. Footnotes pointed to drafting notes and committee intents that weren't commonly known or easily accessible. To legal professionals reviewing the case, the implication was clear. This wasn't someone quoting the law. This was someone who had shaped it. Word traveled quickly among attorneys, regulators, and investigators. By the time it reached the HOA's legal counsel, the tone of communication shifted again. Deference replaced dismissal. Requests were framed carefully. Assumptions disappeared. The board, however, learned the truth last. They discovered it not through a briefing, but through a leaked message, an internal exchange forwarded anonymously, likely by someone already distancing themselves from the fallout. The message mentioned the homeowner's prior work on association governance statutes, expressed concern about exposure, and questioned whether continuing to resist was legally survivable. Panic followed. Board members who had once spoken with authority now avoided eye contact at meetings. Emergency sessions were called only to be adjourned early due to lack of quorum. Motions were proposed and withdrawn within minutes. Every decision carried risk, and no one wanted to be the one whose name appeared on the next filing. Residents noticed the paralysis. Maintenance requests went unanswered. Enforcement notices stopped entirely. The HOA's once aggressive presence evaporated almost overnight. The organization still existed on paper, but its confidence was gone. What remained was fear. Fear of saying the wrong thing, signing the wrong document, or leaving a trail that could be traced back later. Meanwhile, the investigations converged. Regulators compared notes. Fire investigators shared timelines. Financial auditors flagged irregularities that demanded explanation. The same few board members appeared repeatedly in reports, linked not just by position, but by decision-making patterns that suggested coordination. One contractor, faced with mounting pressure, amended earlier statements. Another provided records that contradicted the HOA's official account. Payments once described as routine maintenance were reclassified under scrutiny. The narrative the board had relied on began collapsing from the inside. The homeowner filed an amended complaint. This version expanded the scope of the civil action, incorporating findings from regulatory inquiries and preliminary fire investigation results. It included new claims tied to retaliation, conspiracy, and willful destruction of property. Each claim was supported by evidence that had not existed when the original complaint was filed. The request for injunctive relief was granted. With a single order, the HOA's enforcement powers were suspended indefinitely. No fines could be issued, no violations could be cited, no actions could be taken against homeowners under the association's authority. The board was reduced to administrative functions only, overseen by a court-appointed monitor. For the neighborhood, the effect was immediate and surreal. Residents who had lived under constant scrutiny suddenly found themselves free from arbitrary rules. No one measured grass. No one photographed trash bins. No one sent warnings about holiday decorations. For the first time in years, the neighborhood felt less like a controlled environment and more like a place where people lived. That freedom came with questions. Homeowners began asking how much authority the HOA had really possessed. They requested copies of bylaws and financial statements they had never seen. They attended meetings with skepticism instead of obedience. The association's mystique evaporated as people realized how much power they had surrendered without understanding. The board attempted damage control. They issued statements blaming miscommunication. They emphasized their commitment to transparency. They framed the situation as a misunderstanding escalated by unfortunate events. None of it landed. The language felt hollow now that residents had seen what the HOA looked like without unchecked power. The fire investigation reached a critical stage. While criminal charges had not yet been announced, investigators identified persons of interest. Timelines narrowed. Communications once thought deleted were recovered. The fire was no longer an isolated event, but part of a broader pattern of intimidation. Insurance companies denied claims tied to the HOA's narrative, citing evidence of intentional acts. Financial exposure grew rapidly. The association's reserves were frozen pending outcome. Special assessments were discussed, then abandoned when residents refused to pay for misconduct they had not approved. The homeowner remained largely absent from public view. He didn't attend meetings, he didn't give interviews, he didn't explain himself to neighbors seeking reassurance. His presence was felt entirely through filings, orders, and the slow dismantling of an institution that had overreached. Behind the scenes, he began planning the future of the property. Rebuilding was no longer just about restoring what was lost. It was about reclaiming autonomy. The land still existed, the rights still applied, and now those rights were reinforced by a legal record that made future harassment nearly impossible. As pressure mounted, cracks within the board widened. Another resignation followed, then another. Remaining members attempted to shift blame onto former colleagues, arguing they had relied on bad advice or incomplete information. Those defenses failed under scrutiny. Fiduciary duty didn't disappear with ignorance. The HOA's attorney withdrew. Conflicts of interest and mounting exposure made continued representation untenable. New counsel was retained, but the tone was different. The focus shifted from defense to mitigation, from control to survival. The homeowner received another settlement offer. This one was larger. It included compensation for the house, additional damages, and a proposal to dissolve the HOA entirely. The offer came with confidentiality provisions designed to bury the story. Once again, he declined. Dissolution without accountability would leave questions unanswered. It would allow individuals responsible for destruction to walk away without consequence. That wasn't acceptable. The law wasn't just a tool to escape harm. It was a mechanism to prevent it from happening again. As the neighborhood watched the HOA unravel, a realization spread quietly from house to house. Authority, once questioned, rarely survives intact. And institutions built on compliance rather than consent collapse quickly when challenged. The fire that destroyed one home had ignited a process far larger than anyone anticipated. And as the investigations neared their final phase, the HOA faced the certainty that its end would not be quiet, negotiated, or forgotten. It would be documented, and it would be permanent. By the time the fifth phase of the ordeal began, the HOA existed mostly as a name on paper and a cautionary presence in court filings. Its authority had been stripped, its finances frozen, and its leadership scattered. What once operated with confidence and intimidation now moved only when compelled by legal order. The illusion of power had dissolved, replaced by accountability it had never prepared for. The court-appointed monitor took control of the association's remaining functions. Every transaction required approval. Every communication was reviewed. Records that had once been guarded or altered were now catalogued and preserved. The process was slow and uncomfortable, but thorough. For the first time, the HOA was being forced to operate the way the law had always required. The findings were damning. Years of mismanagement came to light in stark detail. Unauthorized fines, improper enforcement actions, selective targeting of homeowners who questioned authority, financial decisions made without approval, justification, or transparency. The monitor's reports read less like administrative summaries and more like an audit of systemic abuse. Each report was filed publicly. Residents read them with growing disbelief. Many recognized their own experiences reflected in the pages. Letters that had never made sense, fines they had paid without understanding why, threats they had quietly complied with to avoid trouble. The realization that these actions were not isolated but deliberate changed how people saw the neighborhood and the association that claimed to govern it. Class action discussions began quietly. Homeowners compared notes. Documentation surfaced from dozens of properties. Similar language, similar timelines, similar pressure tactics. The pattern was unmistakable. What had happened to the house on the edge wasn't an anomaly. It was the most extreme example of a system designed to punish defiance. Attorneys took interest. The scope of potential liability expanded rapidly: refunds of improperly collected fines, damages for harassment, legal fees, punitive exposure. The HOA's insurance policies, once assumed to be a safety net, were reviewed and found wanting. Many exclusions applied. Intentional misconduct voided coverage. The association's remaining assets dwindled. Meanwhile, the fire investigation reached its conclusion. Arson was confirmed beyond dispute. Responsibility was narrowed to individuals with motive, access, and a history of involvement in the harassment campaign. While the legal process moved carefully, the direction was clear. This was no accident. It was retaliation. Criminal referrals were made. The civil case expanded again, incorporating the investigation's conclusions. Claims of conspiracy and intentional infliction of harm were strengthened by findings that could no longer be dismissed as circumstantial. The narrative shifted decisively. This wasn't about an HOA overstepping its authority. It was about an organization that believed itself untouchable, acting with impunity until confronted by the very laws it ignored. The homeowner's role in drafting those laws became widely acknowledged in legal circles. Articles referenced the irony without exaggeration. Commentary focused on how safeguards designed to prevent abuse had finally been tested under extreme circumstances and held. He remained absent from the spotlight. While others spoke on his behalf, he continued working through formal channels, letting the process unfold. His restraint stood in sharp contrast to the chaos the HOA had created. It underscored the difference between power used responsibly and authority wielded recklessly. Rebuilding plans for the property were approved. The court clarified that no HOA approval was required, no architectural review, no compliance checks. The land's status was reaffirmed under its original covenants, free from association control. Construction could proceed without interference, protected by injunctions and legal precedent. The new plans were symbolic. They retained the independence of the original structure, but incorporated resilience, fire-resistant materials, clear boundaries, no concessions to uniformity. The house would stand as it always had, separate by right, not defiance. Within the neighborhood, conversations changed tone. People spoke more openly now. They questioned past decisions. They challenged assumptions. Some expressed guilt for having stayed silent when the house was targeted. Others admitted they had believed the HOA's narrative until evidence proved otherwise. The sense of community ironically began to recover only after the association's grip loosened. As legal deadlines approached, the HOA's remaining board members faced individual consequences. Depositions were scheduled. Personal counsel advised cooperation. The comfort of collective decision-making was gone. Each member was responsible for their own actions, their own votes, their own signatures. Memory lapses and ignorance offered little protection against documented intent. One by one, stories changed. Accounts contradicted earlier statements. Emails resurfaced. Attempts to minimize involvement were undermined by records preserved too late. The unraveling was complete. The homeowner declined one final settlement offer. It was framed as a last chance to resolve matters quietly before judgments were entered. The offer acknowledged wrongdoing without admitting liability. It promised closure without accountability. Once again, he refused. Closure without accountability was the problem in the first place. As hearings approached and the possibility of dissolution became unavoidable, the neighborhood braced for the final outcome. No one knew exactly how it would end, but everyone understood that it would not resemble the beginning. The HOA that had once enforced conformity through fear was about to become a case study in what happens when authority forgets its limits. The end did not arrive with chaos or spectacle. It arrived with paperwork, rulings, and signatures, quiet, permanent things that carried more weight than outrage ever could. By the time the final hearings began, the outcome was no longer a question of if, but how completely the HOA would be dismantled. The courtroom proceedings were methodical. Evidence was presented in layers, each one reinforcing the last: financial misconduct, abuse of authority, retaliation, conspiracy. The record spoke for itself. There were no dramatic defenses left, only acknowledgements wrapped in legal language and attempts to limit personal exposure. The association's actions, once justified as community enforcement, were redefined as systematic violations of law. Judgments followed. The HOA was formally dissolved by court order. Its governing documents were voided. Its assets were liquidated under supervision, with proceeds allocated toward restitution, legal costs, and damages. Improperly collected fines were ordered returned to homeowners. Outstanding enforcement actions were nullified. Liens and penalties were erased as if they had never existed. Individual liability remained. Former board members faced civil penalties tied directly to their conduct. Some avoided criminal charges through cooperation, others did not. The legal system, slow but relentless, treated each role according to evidence, not title. The idea that serving on a volunteer board excused abuse was rejected outright. The fire case reached its resolution. Those responsible were identified and charged. The motive was established clearly: retaliation fueled by perceived loss of control. The act that had been meant to silence resistance instead became the most incriminating proof of intent. Consequences followed in the only way they could. With the legal process concluded, attention returned to the land. Construction on the new house progressed steadily. Where charred remains once stood, foundations rose with intention and care. The structure took shape not as a monument to conflict, but as a restoration of autonomy. It was modern, resilient, and unmistakably independent. No HOA colors, no approved palettes, no conformity clauses. Neighbors watched quietly. Some stopped by with apologies that arrived too late but were sincere. Others simply observed, learning from the example without speaking. The rebuilt house changed the landscape in a way rules never had. It stood as a reminder that authority must be earned, not imposed. The homeowner moved back in without ceremony. There was no celebration, no announcement, just a return to a place that was finally, unquestionably his. The quiet felt different now, not tense or anticipatory, but resolved. The conflict that had once dominated the neighborhood had been replaced by clarity. In the absence of the HOA, residents organized differently. Informal agreements replaced rigid enforcement. Maintenance was handled cooperatively. Disputes were addressed directly, without threat letters or fines. Property values didn't collapse as predicted. In many cases, they improved. The fear that had justified control was revealed as unnecessary all along. The story spread beyond the neighborhood. Legal journals referenced the case. Advocacy groups cited it as precedent. Homeowners elsewhere recognized patterns they had lived under and began asking questions of their own associations. What had started as a single act of defiance became a broader reminder that governance without accountability is not governance at all. The homeowner never claimed victory. He understood that the law was not a weapon, but a boundary. His role had been to reinforce that boundary when others chose to ignore it. The outcome wasn't revenge, it was correction. Years later, the fire would still be remembered, not for the destruction it caused, but for what it exposed. The moment when authority overreached so far, it revealed its own fragility. The moment when laws written to protect were finally allowed to do their work. The neighborhood settled into a new normal. Children played without surveillance. Lawns grew uneven without consequence. Decorations stayed up a little longer than before. Life resumed in small human ways that no rulebook could ever fully regulate. The rebuilt house remained on the edge, just as it always had, separate but no longer isolated. The HOA that tried to erase it became a footnote, a lesson recorded in case law and memory, a reminder that power without restraint eventually destroys itself. And in the end, the greatest consequence was not the dissolution of an association, or the punishment of individuals, or even the rebuilding of a home. It was the restoration of something far more difficult to reclaim once lost, the right to stand your ground and be protected by the law you believed in all along. If you liked this story, please like, subscribe, and share it with others so they can learn something from it too.